your lordships had seen on the last occasion, on internal page 230 of the judgment, the division bench observes that it will be noticed so and so. It is settled by SPP and company that section 16 of the 96 Act has full play only after the arbitral tribunal is constituted without intervention of the court under 11. This qualification was added by the 7 judges. They go back to the concept of court with intervention of court, without intervention of court. That aspect, my lord, stands legislatively overruled, though that ghost of, my lord, SBP still seems to haunt us. It is also referred to in Justice Khanna's judgment, because after all, my lord, 7 judges, it's difficult to reconcile the fact that the legislature has, my lord, changed the rules of the game, as it were. But it has, my lord. 232, my lord. Page 24. In view of the law laid down by the 7 judge bench, difficult to accede to the argument made by learned counsel on behalf of the respondent. Section 16 makes it clear an arbitration agreement, the independent existence of its own, must be applied while deciding an application under Section 11. Well, Lord, I would respectfully submit that this may not be quite correct. Certainly, when deciding what is the scope of 11.6a, your lordships will also take into account Section 16 and give it whatever the meaning that it is to be given. Not without going into whether it was intervention of court. That's one criticism. My lord, 19 and 19, my lord, is another paragraph which one is criticizing, my lord. And I'll explain why, my lord, what the problem here is. It is seen that neither in the statement of objects and reasons nor in the Law Commission report there is any mention of SMST estates. Correct? This is for the very good reason that the Supreme Court or the High Court, while deciding a Section 11, does not in any manner decide any preliminary question arises between the party. No problem.
No, one thing.
Yes.
No, the paragraph 18 itself.
18.
You said that, no, it is the bench said it is settled by in so and so that Section 16 of 1996 Act has full play only after the arbitral tribunal is constituted. Without the intervention.
Without it.
That maybe one reason may be there, because see, under 16, jurisdiction that can be decided, existence, and then the other question. So 3.
But existence, validity, and jurisdiction.
Validity. These are the 3.
Right.
And then intervention of court under 11. 11, of course, we know that the examination should be confined to existence. So once existence is decided by the court, full play cannot be, because existence already the court entered into a finding.
That was the.
So if intervention is not there on all the 3, jurisdiction, validity, existence,
that was,
therefore full play. That may be the reason why they went upset like that.
That was the reasoning given, my lord, by the majority in SPP. That was in fact the reasoning given. But, my lord, but as it happens, my lord, the legislature has, my lord, taken a different view, and it says notwithstanding any judgment, etc., of any court, and specifically, my lord, SBP is mentioned in the discussion, and catena of judgments, now your lordships have held that it is overruled.
The other day also we put the question. Yes. See, Section 11, it is the same power. Can you say that that particular power can be, or it can have full play only if the question is, that particular question is answered in the negative and in the affirmative?
Well, not if it is answered.
Affirmative, it can only be a prima facie
conclusion. If it is answered in negative, 16 doesn't come in at all.
Definitely.
It's over.
Definitely.
So, but if
had that been the intention, the legislature would have specifically stated so, especially taking out of the fact that in 1940 Act, Section 33, there that question can be considered and answered only by the court.
Only by the court.
Only by the court.
Now,
so that was the position.
So
if it has to be changed in toto, it would have been specifically mentioned.
My lord, in fact, the section actually says, notwithstanding any judgment of the to the contrary, including judgment of the Supreme Court, my lord, it shall confine itself. My lord may just see that provision, and the legislative history also seems to suggest that the reasoning of SBP, my lord, is not something that we are my lord, going back to. There is an issue there, my lord. Your lordship may still feel SBP survives, But that seems to be the legislative intention.
That is why we said that no harmonious construction is required. Otherwise, the power under section 16, we will have to say that it is limited and it is conclusive only if it is said that it is not in existence.
Right, Manoj, that
Existence, it can only be a prima facie conclusion.
yes, Manoj, that's how your lordships have reconciled it in that Mayavati. Anyway, Manoj, I will this question, Manoj, to the extent it may not strictly arise, because Manoj, here we are looking at something beyond existence. In this case, Manoj, we are not discussing on stamp duty, Manoj. We are not questioning, Manoj, my
only because you have made such a submission.
No, my lord, I am making that submission only on the basis of the other three judge bench judgments. This is two judge bench. There are other three judge benches. All have taken that view. I'll show those on Mayavati trading. The same learned judge has taken the view in my lord subsequent judgments in three judges. So my lord,
the concern is not so much about existence or non-existence or even non-payment of stamp duty. Concern is over admissibility of a document which contains the arbitration clause.
Correct, Manoj. So, Manoj, therefore, this issue that because I'm extremely grateful for that observation, Manoj. But this judgment, let me place this judgment, goes only on the basis of existence. That's the problem with the judgment, Manoj. Why, my lord, is this judgment be referred has been doubted in NN Global? Because the focus in this judgment, my lord, is only on the phrase existence in law, which according to me, my lord, has nothing to do with stamp duty. That's a completely separate question, my lord. So, my lord, let me just place this. What is the problem? So, my lord, 18, debatable, your lordship has put it to me, I will not put the point. Please focus on 19 and 22, which is specifically referred. Then, the third sentence. The Supreme Court or the High Court is only giving effect to the provisions of a mandatory enactment, which no doubt is to protect revenue. There's no analysis of 33, 35, what is the effect, whether it is a valid agreement which requires stamping or not. It is a statement that since that is mandatory and you have to then follow it. Then, Manoj, the next sentence. A close look at 11.6a would show that when the Supreme Court or High Court considers an application and so and comes across an arbitration agreement, a clause in an agreement or conveyance which is stamped, it is enjoined by the provisions of the Stamp Act to first impound. Manoj, this does not flow from 11.6a at least. Then, my lord, it is important to remember Stamp Act applies to the agreement conveyance of a whole. Correct, my lord, no dispute. Not possible to bifurcate the arbitration clause as has been conducted. My lord, no dispute. Then last line. It is clear, therefore, that the introduction of 11.6a does not in any manner deal with or get over the basis of the judgment which continues to apply even after the amendment of 11.6a. My lord, I would respectfully submit that the introduction of 11.6a and the language of 11.6a actually gets over the SMST estates problem. Then, my lord, 20 and 22, my lord, are critical. Looked at from a slightly different angle, an arbitration agreement which is contained in an agreement or conveyance is dealt with in 7.2 of the 96 Act. My lord, interestingly, 7.2 also has arbitration agreements, whether contractual or not. So you can have an arbitration agreement in respect of non-contractual matters. That is how
National Highway Authority.
My lord, even tortious matters can be referred to arbitration. So, my lord, in fact, it is a copy, cut and paste of the model law, which is a copy, cut and paste of the New York Convention. So Article 2.2 of the New York Convention becomes Article 7 of the model law, which becomes our Section 7. No difficulty. We are concerned with the first part of 7.2 on the facts of the case. Therefore, arbitration clause that is contained in some contract in question is subject matter presently. It is significant that an arbitration agreement may be in the form of an agreement clause in a contract. Now, my lord, the learned judge now refers to certain provisions of the Contract Act. And my lord, I would respectfully submit that this is absolutely important for us. Sections 2A, 2B, 2G, and 2H read as under. My lord, I would pause here for a moment. Before your lordships come to para 22, please see the contract act, because something turns on this. And Justice Nichachar. But section 2 is the interpretation clause. My lords, A, B, C, D, your lordships will ignore. 2E. 2E is every promise and every set of promises forming consideration for each other is an agreement. So, my lord, agreement is treated differently from a contract. F, promises which perform consideration, my lord, F, your lordships will also not note. 2E, your lordships are noted. Then G, H, which is quoted in Garware, but please also note I and J. There are 4, my lord. There's an interplay of 4. G, an agreement, and this is where the phrase comes, my lord, not enforceable by law is said to be void. H, an agreement enforceable by law is a contract. I, an agreement which is enforceable by law at the option of one or more parties is a voidable contract. And J, my lord, a contract which ceases to be enforceable by law becomes void when it ceases. So, my lord, four aspects your lordship will see. My lord, G and H are two sides of the same coin. G is an agreement not enforceable law, result void, and enforceable by law contract. So, my lord, this is a binary choice. I and J, my lord, is voidability, but the agreement has already, my lord, become a contract and can be avoided. And J is, my lord, a contract has already happened, and later, if you later it becomes void, then it ceases to be enforceable. So, my lord, this is this is clear, my lord, from section 10 also of chapter 2. Contracts, voidable contracts, and void agreements. What agreements are contracts? Not all agreements are contracts if they are made with free consent, competent to contract, lawful consideration, and are not expressly declared to be void. So, my lord, then the chapter, it goes on to show what contracts are void, what contracts are voidable, etc., etc. Your lordships are familiar with this. So, my lord, in this light, I will also show a very short judgment of Justice Nijjar on these provisions of the Contract Act. In Swiss timing, I'll show that. But now please come back to para 22. When an arbitration clause is contained in a contract, it is significant that the agreement only becomes a contract if it is enforceable by law. No problem, law. We have seen how under the Stamp Act, an agreement does not become a contract, namely that it is not enforceable in law unless it is duly stamped. I, my lord, respectfully submit that this is an error. This is really the error, my lord, in the judgment. Because under the Stamp Act, as I have, my lord, sought to demonstrate to your lordships, the unstamped agreement is a valid contract, valid under law, may be inadmissible in evidence. If I put it the other way, my lord, it is not a 2G situation where the agreement is void due to non-stamp. It is not void. My lord, 2G is only enforceable, not enforceable law. Consequences void. So, my lord, it is not void. If it is not void, it is valid. And if it is valid, my lord, it is a contract. So, my lord, this is where the error. Therefore, even on a plain reading of 11.6a, when read with 7.2 of the Act and 2H, my lord, 2G has been missed out, we would make it clear arbitration clause in agreement would not exist when it is not enforceable by law. My lord, in fact, it is enforceable by law in the sense that it is not void. Enforceable by law has been explained as not being void.
Because it is curable.
Because it is curable. I am obliged. Because it is curable, it is not void. If it is not void, it, my lord, exists as a matter of law. If it exists as a matter of law,
What do you mean by enforceability or unenforceability of an instrument?
my lord, yes, please see G.
No, what do you mean by enforceability as you understand?
My lord, it is enforceable by law.
So how do you enforce a contract instrument?
Sorry, my lord.
How do you enforce a contract? Let's take the case of a contract.
My lord, you enforce it by, my lord, putting it before a forum, and my lord, and then, my lord, proceeding.
So when you say it's not enforceable in an unstamped condition, would it not mean that you cannot enforce the rights flowing or the liabilities arising therefrom through a court of law or any other
My
forum?
lord, enforceability has different
It's in
meanings.
that sense, perhaps.
In that sense. But my lord, the conclusion is that it would not exist. That's the conclusion.
Take for example, there is an unstamped document.
Right.
Without reference to the court, parties actually receive payments,
Yes.
perform their obligations under the contract.
Right.
In that sense, of course, it continues to exist.
My lord,
One way of looking at it.
yes, my lord,
But
that's
the
what I'm.
enforceability part is to be viewed from the perspective of a party going to a court
Or a dispute. Yes.
and seeking to actually get the sanction of the law to actually make the other party respond to it.
My lord,
So that there it
Lord,
runs into a problem because you can't enforce it because it can't be used.
there are, my lord, if I can put it in simple terms, 3 concentric circles. One is, does it exist as a matter of fact? That's the most narrow view you can take of existence. That yes, the document says A, B, C, D, E, F.
If it exists.
It exists. My lord, the second in which I am canvassing for your lordships, because we are known only on the word existence, my lord, because one section says existence, section says existence, validity, one section says jurisdiction. So, my lord, existence, option 1, only in fact. That was argued in my lord, in this case. I am not going for such an extreme proposition that all that the appointing authority has to do is to read the document and say, all right, that clause is there, good enough. No. My lord, I concede for the purpose of this, my lord, argument that existence must also mean existence in law. Now, in my respectful submission, my lord, existence in law means that it is, my lord, valid. Because that's the second word, my lord, valid. I.e., it is not void, my lord, void and valid. If your lordship sees G and H, the two sides of the coin, void and, my lord, not enforceable is a contract, and
Implication of inadmissibility.
my lord,
That we'll have to address.
implication of inadmissibility, my lord, is the third stage. It's the largest of the concentric circle, my lord. Stage, if, my lord, your lordships are now interpreting 11.6a existence. That's the word which is used. 11.6a existence, does it mean existence in fact? That's too extreme. Does it mean existence in law? Yes, certainly. The court.
Existence in paper.
My lord, it's a valid agreement. Every judgment under the Stamp Act says it's a valid agreement.
It's a valid agreement, but unless becomes
Lord,
enforceable.
There, my lord, your lordship has to see the language of 2G. Not enforceable by law.
Yes, so
Is said to be void. My lord, that expression has to be given the meaning. It is not, my lord, it is not generally we are saying whether it is enforceable or not enforceable. The question is validity or voidness. Then, my lord, we come to admissibility. Admissibility, my lord, classically is a matter which is left, my lord, to the adjudicator, the arbitration, the authority.
here, 11 court becomes the adjudicator.
My lord, that's
as far as the existence of the.
My lord, that's the question, my lord. Does it become the adjudicator? The moment, my lord, we come to that stage of saying it is adjudicating or deciding, is it deciding existence?
Mr. Banerjee, what is our job then?
My lord,
to High Court or Supreme Court,
my lord,
just to tell us that in this paper there is an
my lord,
clause and
unfortunately, my lord, that is the limited scope of 11. And unfortunately, my lord, it has been placed before the court. And my lord, what your lordship's job is, if I can respond straight away to it.
job is primarily to name the arbitrator.
No, my lord. I will give your lordship what is within the scope of 11. And please see, my lord, Swiss timing. Please see Swiss timing because it explains the scope. It is not a ministerial or post office, my lord, that is being done. It is a narrow scope, but it is still a scope. I am not saying, my lord, it's a post office. I am saying there is a scope, and please see 2014, 6 SCC 677. My lord, your lordships are essentially acting as the appointing authority.
So we have to see the value. Don't we have to see the eligibility criteria?
Sorry, my lord.
If we are acting as appointing authority,
Yes.
then eligibility.
Yes, my lord. Your lordships will have to see whether notice was given, whether it is premature, whether the procedure has been followed, whether there is an agreement, whether it's a legal agreement. All these court has to see.
Swiss timing, which proposition you are?
My lord, Swiss timing is only it's a order of a single designate judge, so it has no, my lord, precedent value. But it is a judgment, my lord, which this is 2014 6 SCC 677.
Not many in the Supreme Court can have a privilege of this kind of a reported judgment.
On
Single bench.
Single bench. My lord, earlier the single bench used to happen in section 11 only because it was a designate judge. So, my lord, some of these, in fact, in Swiss timing, the learned single judge actually sought to overrule Radhakrishnan Maestro. So, my lord, I am not going on the merits, my lord.
Only in this jurisdiction.
I am only showing paragraph 25 and 26. 25, 26, 27, my lord. 25 starts at, my lord, 691. At 25, I'm not going to no, this is on voidability and voidness, and then 26. What is said, my lord, at para 26 at 692, the cases where a clause is patently void are cases where this court, my lord, or indeed anybody will finally, my lord, stop the process. If you can find, my lord, that the clause is patently void, then you will, the appointing authority, my lord, court will not appoint somebody and find that this clause is such that regardless of the fact that it is there, it is ex facie void and an appointment will not be made. Even voidable cases of voidable, my lord, agreements ought to go to the arbitrator to decide, my lord, on the merits. You know, that's 27. And 28, my lord, is the ratio of the case. So, my lord, if one can go back to 11, 11 is a provision which is only triggered when parties do not agree and the court is to act as an appointing authority. Only when the procedure fails. It's not a, Lord, it was never conceived to be a court of any detailed inquiry. Vidya Drolia, my lord, also makes that clear. Every single judgment, my lord, even SBP, my lord, makes it clear.
There is yet another single bench judge.
Sorry, my lord?
There is yet another single bench Justice Jagannath Rao's single bench judge.
Justice Rao's judgment, my lord.
I think it is there first.
For the aspect of fraud covered, whether fraud not covered, that, my lord, I asked Swami that there is a series of judgment. I am only relying on this for the analysis of the provisions of the Contract Act. That's the only reason, my lord, I am relying on this. And
So the
therefore,
argument is that under the Contract Act, an unstamped agreement is not void.
is not void.
And even if it is unenforceable, it is still not void.
My lord, it is I'll just read this, my lord.
Because that's a curable.
Yes, my lord, an agreement not enforceable by law is said to be void. So it is not an agreement, it is not such an agreement. Otherwise, the natural consequence of that would be that it would be void. It is not void. My lord, it cannot be argued that it is void today.
What does the Stamp Act do actually?
My lord, the Stamp Act,
It enjoins the court from not looking.
my lord, the Stamp Act only impacts, as your lordship put it, admissibility.
Yes.
Right. Now, my
If
lord,
document is not admissible.
admissibility. My lord, it is an evidentiary bar.
Yes.
It is an evidentiary bar. My lord, I'll come to acted upon separately. It is an evidentiary bar.
Yes.
That
Now,
evidentiary bar.
I posed this question yesterday. When to refer a matter to arbitration, to appoint an arbitrator, it's implicit that we'll have to look at the document
My lord, that,
in which there is an arbitration clause.
my lord, that will not
Whether-
tantamount to either admission.
Clarify that stand. What you are
Yes, my lord. My lord, there are two ways in which section 33 and 35 will not apply, my lord. I will put them, my lord, at the end, along with the compilation of judgments on the 1940 Act, what was the position under the Stamp Act. I'll show that, I will contrast this. And my lord, this specific question of evidentiary bar and, my lord, not admissible and not acted upon, my lord, I will deal with separately. I am only at this stage showing the errors in the reference judgment. Because this, my lord, in my respectful submission, my lord, 22, he says, 2H of the contract would make it clear that an arbitration clause in an agreement would not exist when it is not enforceable by law. My lord, this does not appear to be, with respect, correct, because, my lord, it does not take into account 2G and it does not take into account the Stamp Act series, because it's not really been, my lord, considered. So that is all I am saying, my lord, about this portion of the judgment. There is no discussion about curability, validity, voidness. There is no such discussion. It's a simple conclusion based on the provisions of the Contract Act, with respect do not appear to have been read in the way, my lord, that I am submitting. Your lordships may read it. So 22 is, according to me and according to, my lord, a 3-judge bench, a matter which your lordships should look at. That's what we are saying. My lord, your lordship is Wellington Associates Kirit Mehta is that Justice M.J. Rao's single bench. That was, yes. No, that all that went up to that SBP route. In fact, Justice Rao's judgment was then taken, and, my lord, in the reference that was also cited. So, my lord, the other paragraph of this reference judgment, which is the subject matter of doubt, is para 29.
Para 29
Of Garwari.
Garwari.
2 paragraphs were spotlighted by the bench in NN Global. Para 22, which I, my lord, respectfully submit, does not summarize the law correctly, and NN Global was right in doubting it, because it is not a question of non-existence.
NN Global says this agreement is not to be stamped.
Sorry?
NN Global says not to be stamped.
NN Global, my lord, frames the question, say, it is a matter, my lord, where my lord, NN Global finally says all sorts of things, but
No, but I think 20.
yes, 24, 25, 26.
Not to be stamped.
Yes, I'll place that also.
says the arbitration agreement does not require stamping under the Maharashtra Stamp Act.
But this act is also corresponding same.
Same thing.
Just section number maybe 33.
So principally is the same.
Principle is the same.
My lord, now your lordships will see 28 and 29 because
Have you
20.
examined from this context also?
Sorry, my lord.
Your line of argument is that it has to be stamped.
My lord,
How to come out from the rigor of stamping? Have you
It has to be
examined from
stamped.
this context also that it is not required to be stamped.
My lord,
Because if it's not required to be stamped,
my lord, I can't.
Easier.
I can't argue that. On Tuesday, my lord, that appears to be a problem with that judgment. My lord. It will require to be stamped at some stage. Even a standalone arbitration agreement may require to be stamped. It may require to be stamped. So, my lord, that's why I started by saying that I have some difficulties with NN Global also, and I have some difficulties with Garwade also. But your lordships will have no difficulty.
Proposition is brought in Maharashtra
Yes.
Amendment 2C, I think.
Yes.
That puts in the.
So, my lord, that's the benefit of, my lord, being before a 5-judge bench where lordships can lay down the law and your lordships are not bound by the reasoning of either of the 3 judges.
I was examining this in context yesterday. See the Stamp Act and Article 5C, any other agreement and all.
Yes.
A and B are in different contexts.
A and B are,
C is residuary.
C is residuary.
So C has to.
I am obliged, my lord.
Only
In fact, my lord, there are.
Taking the principles of as a generalist of A, B, and C in the light of context, can't the paragraph 22 of the judgment under reference?
My lord, there are some
Proves the view.
possible, my lord. I had not thought of it in that way, my lord. But there are some judgments which. That is what your lordship is.
If we take in totality of the matter,
My lord, that may
the very
be.
purpose of arbitration because of this trigger here is going to be frustrated. Ultimately, we want to see the system to make workable and effective.
That's right.
But we just take the short routes somewhere else, and the main dispute arising from the contract to be resolved by the arbitrator goes somewhere else.
That is football, my lord.
Football. So to sum up and to put the things into order and see that the dispute among the parties.
My lord, the
arising from
starting line must be
contract
crossed.
Focused and effectively deliberated is cited.
The starting line has to be crossed in the marathon. When you start running, you have to get past the starting line. If you are stuck at the starting line, then there's a problem. But then you go off on a tangent somewhere else, go to the district collector, and then it's all over.
The analogy of marathon may not be correct because the process is expected to be a sprint run.
Right. Sprint run. But it is a marathon. That's unfortunate because I am taking into account award, appeal, execution. But I was doing an execution, my lord, in a matter. I was doing an appeal in a matter, my lord, before another bench, where the matter had started in 1960, argued arbitration conducted by my late father. Then the setting aside in Calcutta High Court in the 80s, conducted by my brother, and then, my lord, in 2020 it had come here. So, and it was 7 lakh out.
It is all the more necessary we should keep in mind that if this is the fate of the arbitration,
We should.
then we have to.
But, my lord, situation has improved, my lord. The arbitrations have speeded up because of this new law. There's a difference. The arbitrators are also under some pressure to my lord, expedite matters. Though there are, of course, my lord, some cases where even that has not made a difference. But certainly.
That McDermott matter.
That was, my lord, this was J Engineering work.
McDermott also.
Also, my lord, took its own time. The lordship is
Has
right.
it attained conclusion?
Yes, my lord, we got 5 lakhs at the end. 1960 award, we got 5 lakhs.
Because I am
We thought whether you'd be passing it as an heirloom. to your son.
No, my lord. Fortunately, no member of the family is a lawyer, my lord. That's the good part is no member of my family, my lord, of next generation has thought it's an unfit profession, my lord. They think we work too hard.
Yes, I'm in a matter for enforcement of a foreign award. The arbitration proceeding took 2 months. Award came in 2010. I came to India for enforcement in Nagpur. It's been 13 years. Amount recovered is zero. All courts, including this honorable court, recorded judgment in my favor. But review has been filed, everything has been stopped. Court said, I will not do it. Review is pending. 13 years, nothing recovered. In execution of a foreign award.
But now possibly you might get interest.
No court is giving the money. Even the amount which is deposited, which is the INR amount, I have not been able to withdraw. Because it says review is pending in Supreme Court, nothing doing. We will not touch. So this is one situation.
Is somebody there amongst us to address on the view expressed by a reference?
There are other people, my lord, who may support that view, my lord. It may be, my lord. I am taking a very conservative approach because there is a very old judgment, my lord, 1800 judgment which says arbitration.
So, you argue number of cases. You find your name everywhere.
Garwani was argued by me, my lord.
My lord, on the other side.
Also argued by me, my lord. Side effect for the Krishna in group.
And now you are watching now.
Which escaped to my lord.
My lord, may come to paragraph 28 and 29.
The only thing which I feel, my lord, is the issue of section 9 application. And if an objection is taken, my lord, there may be some time taken for my lord because the document will have to be impounded. That's the only grey area which I think perhaps your lordship may need to tweak, my lord. Because, my lord, the idea of a section 9 is to, my lord, get an urgent interim, my lord, order. Or if, my lord, an objection is taken, that, my lord, the document is unstamped, lord, then it is going to take time. Unless, my lord, your lordship agrees with, my lord, Justice Nariman's view in Garwani, the last paragraph, where it is indicated, my lord, that they will make it time-bound, my lord. If your lordship has para 37 in Garwani, my lord.
My lord, that.
Otherwise, my lord, section 9, my lord, the very purpose, my lord, would be frustrated. That's the only area where I feel, my lord, some tweaking may have to be
9
done.
is a more difficult territory.
My lord, 9, I am not going into 9, my lord. 9.
I will, my lord, submit on
Nine.
it.
Otherwise,
We are on 11.
But my lord, I will show that based on what my lords will hold, my lord, 9 is going to be substantially.
No, 9 is pending separately, my lord.
the full bench judgment of
The full
Bombay
bench
High Court.
judgment is pending separately, my lord. So let's not, my lord, expand the canvas. Then I will have, then 9 we will go into, my lord.
My lord will have to notice it, my lord. Otherwise, if it is not argued, my lord, that aspect will completely get missed out.
My lord, your lordship, restrict to the reference and restrict to.
This bench is a creature of the reference. So,
Please, my lord, I will show
Confined to
that why 9 is referred in both judgments, my lord, and therefore it can be looked at.
Yes. My lord, may come to para 29, which is page 30. This judgment in Hyundai engineering case, your lordships have got page 30. This judgment in Hyundai engineering case is important in that what was specifically under consideration was an arbitration clause which would get activated only in insurer admits or accepts liability. Since,
Mr. Banerjee, which judgment you are?
my lord, I am still on Garwani.
Para 30.
29. This is the other para which was highlighted, my lord, by the bench. The judgment in Hyundai engineering, and I'll place Hyundai engineering, my lord, because it has some relevance, is important in that what was specifically under consideration was an arbitration clause which would get activated only if an insurer admits or accepts liability. You know, this is well known as the Scott and Avery clause. Since on facts it was found that the insurer repudiated the claim, though an arbitration clause did exist, so to speak, in the policy, it would not exist in law, as was held in that judgment when one important fact is introduced, namely insurer has not admitted accept liability. Likewise, in the facts of the present case, it is clear that the arbitration clause that is contained in the subcontract would not exist as a matter of law until it is duly stamped, as is being held by us. Argument that 11.6 deals with existence as opposed to 8.16 which deal with validity of an arbitration is answered by this court, understanding of the expression existence in Hyundai. So, my lord, the two-judge bench takes recourse to two reasons. One is para 22, where Contract Act is taken into account, and my lord 29, where it purports to follow Hyundai. What it says in Hyundai, something was there, taking an analogy, taking a parallel, the clause here does not exist in law. Now, my lord, the very interesting fact about Hyundai is this. Hyundai is quoted at para 28. The judgment in Hyundai is considered, my lord, by the two judges in Vidyadrolia. One judge says X, one judge says Y. So, my lord, specifically with respect to Hyundai and the reasoning in Hyundai, two judges of this court take two absolutely opposing views in Vidyadrolia. And my lord, that is also there in Justice Khanna's discussion of Hyundai is in paragraphs 113 to 115, and conclusion is at 146, 147. And the exact opposite is in Justice Ramana's judgment at 201 to 203 paragraphs. So, my lord, perhaps your lordships will have to just examine, my lord, what actually Hyundai says. It is something, my lord, which tangentially comes into the reference, because that is an argument which is now accepted by the, or rather a weapon, or rather a reason used by the two judges to justify its stand that the clause does not exist in law. And it says the reason I am saying this is because Hyundai similarly said it. You know, this is the 28, my lord, Hyundai has been set out. Now, 26 and 27, my learned friend wants to show Enercon, my lord, and Duro Felguera, according to the bench, does not, my lord, answer the issue, is what the bench says. My lord, I say, my lord, it does answer the issue. And 28, then Hyundai is considered this three judgment. Now, my lords, if your lordships now turn, before I go to Vidyadrolia, because 2-3 paragraphs of Vidyadrolia have been put in the reference. I just wanted to take 5 minutes on this Hyundai dispute. My lord, Vidyadrolia was a matter with a limited reference. The only issue, my lord, there were two issues in Vidyadrolia. What happened in Vidyadrolia was, it was a section 11 matter. It was a landlord-tenant dispute, and it was a section 11 matter. My lord, I'll just give that background and show the relevant paragraphs. The question that arose before the Supreme Court was, my lord, for rent control matters, of course, my lord, it is not arbitrable. There is no subject matter arbitrability. It is hit by section 2, subsection 3. It cannot be arbitrated. But the question arose whether a landlord-tenant dispute would be the subject matter of arbitration as a matter of law. That was the only question before the two-judge bench in Vidyadrolia. So, my lord, Justice Ramanna framed two questions. Lordship will just see the questions which were framed. Questions, my lord, are framed at page 157 of this compilation. You just see Vidyadrolia. I am conscious that your lordships do not wish to expand and reopen all sorts of aspects of Vidyadrolia, but I am only limiting myself, my lord, to the reasoning with the stamp aspect. Page 157, para 165, if your lordships have. The reference order primarily indicates that there are two substantive issues to be settled by this court, namely, one, to what extent does the court decide the question of non-arbitrability, namely subject matter non-arbitrability, under 11 of the Act, 165.2, whether tenancy disputes are capable of being resolved through arbitration. This was the limited scope of the reference in that case, nothing more. And in fact, the concurring judgment, Justice Ramana says, having answered question 1, that normally this matter should be left to the arbitrator, I would not have gone into question 2 at all, but since it has been gone into, I agree. So, my lord, these were the only 2 questions that were referred. As it happens, in the judgment of Justice Khanna, my lord, which we tend to read initially, a very large number of issues have been discussed. The scope has become quite wide, my lord. And one of the issues which has been discussed, my lord, is what is the meaning of arbitrability. This word does not exist in the Arbitration Act. There is no phrase arbitrability in the arbitration. Arbitrability may have different meanings, my lord. The narrow meaning which Justice Ramana, my lord, takes is, I am only deciding on subject matter arbitrability. I am only deciding on the question of section 2, subsection 3, whether it is the subject matter which is arbitrable or not. That's all. Justice Khanna goes 2-3 steps further. He decides not only a subject matter arbitrability, he also decides on another question which actually is really not a question of arbitrability. Not that question is a little different. If you have arbitration clause X, there may be certain, my lord, accepted matters, matters which are not to be referred to arbitration. For instance, my lord,
2-3, section 2, subsection
2-3, my lord, was the reference. 2-3 is clearly to be decided here, my lord. But what Justice Khanna has done in para 15 is that he has decided, my lord. There's no problem with that. He has made a 4-fold test. He has said what is arbitrable, not arbitrable, in rem, in personam.
within the arbitration clause.
Yes, fine.
Your worry is about within the arbitration clause.
My lord, yes. My lord, now the issue that is there in Hyundai is little different. Issue is, supposing you have an arbitration clause. There's no dispute to have an arbitration clause. But that arbitration clause may be a narrow clause. You may say, I only want to refer A, B, C, D disputes to arbitration. Others are accepted matters. For instance, in Hyundai, Scott and Avery, I only wish to refer the issue of quantum. I don't wish to issue you to refer the issue of liability. Or, my lord, in a standard form construction contract, I don't want to refer issues where the engineer role is final.
In other words, the scope of the arbitration.
The scope of the arbitration. So that was Hyundai.
Separability.
That is, I am obliged. Separately. So, my lord, that issue is different from the issue as to whether the arbitration clause is valid or not. I.e., arbitration clause is legal or not. I.e., is there a bar under law, say, rent control or family, which is subject matter arbitration. These are 2 separate and distinct issues. My lord, that is also made clear in 34 2A2 and 2A4, which is why I had shown these provisions. They are 2 separate provisions. This is where the problem arises. 34 2A2, arbitration agreement is not valid under the law, which is in force. An arbitration agreement between me and my learned friend on my lord, family matters is invalid, void. So, my lord, that is 2. Then 4 is arbitral award deals with a dispute not contemplated by or not falling within the terms of the submission or contains matters beyond the scope. So, my lord, this is a different. This is covering accepted matters. They are 2 different provisions. Now, my lord, unfortunately, in Hyundai, what happened is, my lord, that now in this light, your lordship will see Hyundai and I'll come back to the my lord, those or my lord, let me show how the
Why don't you take us through this Drolia, which
where,
is wrongly decided according to you.
right. My lord,
So we'll know.
Right. My lord, Drolia, my lord,
Paragraph.
but may I do this in reverse, my lord? I'll show Justice Ramana first.
Okay.
Normally, my lord, we see the first judgment first, but I just want to show that first to show, my lord, what has been said. Only few paragraphs. Only for this purpose of, my lord, stamping, not for, my lord, generally.
Yeah. Which paragraph?
My lord, please come. It starts at 156.
It's only supplement, not descending, it's supplement.
It's supplementing, but my lord, my lord, I will show paragraphs which collide, my lord. And that's where the outcome is the same. The result is the same. The reasoning is a little, my lord, this way, that way.
At logarithms with you.
Slightly, there is, my lord, there is an issue. Your lordship will see it. If I can show it, I'll show it. My lord, the judgment begins at page 156.
Can you come to the paragraph which you say?
My lord, the paragraph, I'll come to, my lord, where the judgment of Hyundai is concerned.
Which paragraph?
My lord, 201 to 203.
220.
201-203, page 184.
Yes.
Well, there are some 7-8 other paragraphs I can show. No? 201 is Duro Felguera. 202 is Oriental Insurance versus Narbhiram. Following the decision in Vulcan, Vulcan is the Scott and Avery judgment under the order.
This is Ramana supplementing judgment.
Supplementary judgment at page 184,
180.
182.
Only referring to those judgments.
Right, very interesting. I'll just read it.
But why don't you take us to the exact paragraph where this is makes a particular point?
My lord, please see 203 last sentence. Very interesting sentence, my lord.
Restricted to the facts and such.
Yes, my lord, because he can't overrule it because it's 3 judges, my lord. So, may I just, my lord, run your lordship through the judgment, 5-6 pages, so that your lordship gets the full. It won't take very long, my lord. I'll just show the.
What we talk about? What is it that this is Ramana say? Which is at logarithm with what the.
My lord, one is this portion. One is this portion. More importantly, my lord,
yeah.
The conclusion at 244, 237 and 244 is inconsistent with para 146. So, my lord, 146, 147 is the conclusions of the first judgment, and 237 and 244 are the conclusions of the supplementary judgment.
244.
244. 237 and 244, 5.
Read that.
In Mayavati's 244, 5 valid. The court should refer the matter if the validity of the arbitration cannot be determined, laid down above. When in doubt, do refer, no problem. The scope of the court to examine the prima facie validity of the arbitration includes only whether the arbitration is in writing or whether the arbitration was contained in exchange of letter, communication, etc., whether the core contractual ingredients qua the arbitration agreement were fulfilled, on rare cases where the subject matter disputes is arbitrable. This is how we understand it. And I respectfully say correctly. Now please read, my lord,
you are referring to 237.4.
4, which is reflected in 244.5.
No, we are asking you.
Yes.
You are saying this is correct.
My lord, it should not be disturbed now, my lord. This is a view which has been taken, my lord.
No. What we are asking is something different.
Yes, this, my lord.
For the purpose of section 11, is it for the purpose?
It's for the purpose of 11.
Can we read it on rare occasion?
My lord, that your lordships have left that window, my lord. Our reference will become much larger if we go into that aspect.
No, this is after 6A.
6A.
And after the overruling of SPD, whether this can be.
My lord, I would have a problem with it, but my lord, this is.
So therefore, as
yes.
Michael,
my lord,
what is your stand? Your stand is that this is right, wrong.
My lord, I would say that.
I'd like to know your views.
My lord, my view is that this rare occasion should not be given because rare occasions become.
What is the question of rare occasion? when the legislature says existence, on rare occasion, whether the subject matter dispute is arbitrable.
My lord, say it is patently void, as an example. So, my lord, subject matter is
Arbitrability is different. I mean, unless you confine it to the
2-3.
2-3.
2-3, my lord. It is subject matter of dispute, my lord. He makes this clear earlier.
Okay.
I'll show that, my lord.
It is understood in that sense.
It is understood by him in that sense,
Okay.
not in the other bench.
Then it's okay.
It is understood in that sense. If you're
Supposing a landlord-tenant relationship.
landlord, and my lord, he
Comes to
restricts
11.
it only to subject matter arbitrability, and that your lordships will find
Maybe not arbitrability in the other sense.
not arbitrability in the other sense.
If it's understood in that sense, fine. So now where is the problem now?
My lord, the problem is in the other judgment.
244.
No, in the other judgment. There is no problem in this judgment.
So you are saying this is.
I am saying, my lord, yes, my lord,
Understood in 2-3.
yes, understood in 2-3.
Okay.
Fine.
Now which paragraph of Dolia you want us to?
My lord, I want your lordships to see 146, 147,
146
and 147, which was
doubted by the three judges bench.
which is doubted.
That is-
And my lord, to understand where that comes from, the basis of 146, 147
Yeah.
is 113, 114, and 115. So to understand 146, 147, the reasoning earlier to that, where Gadwade is specifically considered by the first judgment, is at
113.
113, 114, and 115. Gadwade, Narbhiram, and Hyundai.
Straight away, let's go to 113.
Right. Now 130, my lord. Or 113, Gadwade is quoted. That is page 130. Your lordships have come to page 130.
Yeah.
So 113, my lord, it is a quote of Gadwade. It's not it's the sequence. Then, my lord, 114. In Narbhiram Power versus Steel, three-judge bench decided civil appeal arising from application under 11.6, insurance grant, primarily relying upon decision of so-and-so, held disputes not arbitrable in terms of the arbitration clause, as the insurer had disputed and not accepted liability. Arbitration clause applies only if there is a dispute pertaining to quantum. Well, Lord, this is the distinction I made. This decision, though dated 2/5/18, did not refer to 11.6a and interpret the same. So, my lord, there are decisions, and the reason is, my lord, because the notice was prior to, in fact, the Madras High Court from which it came, the proceedings had started before. So, my lord, 11.6 not noticed. So, the judge records, my lord, that, so it doesn't really take the matter. Decision and so, similar arbitration clause. However, in this case, reference was made to 11.6a. Therefore, clear that on two occasions in Narbhiram and Hyundai, a three-judge bench of this court affirmatively in clear terms held that the question of non-arbitrability, this is now the wider phrase of non-arbitrability, relating to the inquiry whether the dispute was governed by the arbitration clause, can be examined by the courts at the reference stage and may not be left unanswered to be examined. So, my lord, now by this paragraph, what is being suggested there is that at a section 11 stage, your lordships will have to interpret the scope of the arbitration clause and decide whether or not there are accepted matters. This was not even the Boghara view. This was not even the Boghara view. The Boghara view, category 3, left accepted matters to be decided by the arbitrator. So, my lord, both Narbhiram, of course, there's no reasoning really, but Hyundai, I will show the reasoning. They couch an issue, make it an issue of arbitrability, and say, now you decide. So, my lord, there's a problem with Hyundai, which is why Justice Ramanna says it has to be limited to the facts and circumstances, facts of the case. These are decisions of three-judge benches quoted with affirmation, Garwal. So, my lord, this is the 3 paragraphs, and the then various books are quoted. Then your lordship straight away go to 146 and 147. 146 at page 149. We now proceed to examine the question whether the word existence in section 11 merely refers to contract formation, whether there is an arbitration agreement, and excludes the question of enforcement bracket validity, and therefore falls outside the jurisdiction of the court at the referral stage. On jurisprudentially and textualism, it is possible to differentiate between existence of an arbitration agreement and validity of an arbitration agreement. Such interpretation can draw support on plain meaning. So and so, however, equally possible jurisprudentially on contextual. Hold that an agreement has no existence if it is not enforceable. Existence of an arbitration presupposes a valid agreement which would be enforced by relegating parties. Legalistic plain meaning contrary. A reasonable and just interpretation existence requires understanding context, purpose, relevant, binding, enforceable agreement. Agreement has no meaning unless parties can be compelled. Party cannot sue and claim rights. Thus, there are good reasons to hold that an arbitration agreement exists only when it is valid legal. Avoid an unenforceable understanding, no agreement. So, my lord, there are there's a little bit of confusion in this paragraph. My lord, existence and contract formation. That is what Justice Ramana says in the paragraph 237 and 244. So, my lord, yes, you have to look at existence. Yes, you have to look at contract formation, but that's about it. My lord, validity, he says, is a question of enforcement. But my lord, validity is valid. A valid contract enforcement is a stage subsequent to validity. A contract may be valid, but yet my lord not be my lord. And the learned judge also recognizes that it is possible to differentiate between the two. So, my lord, 146, last sentence is all right, my lord. There are good reasons to hold an arbitration exists only when it is valid and legal. Avoid unenforceable is no agreement. No problem. So, my lord, the reflection of this is at para 147, 1.
The last part of 146, enforceable in law, you're saying if it is not a void contract.
It's not a void contract.
Within contract terms.
So, my lord, existence.
Not in terms of the stand back.
Not in terms of stand back. Right. Now, my lord, please see the sentence at 147.1 after Garwade is quoted. 29 is quoted. Existence or validity are intertwined. So far, so good. An arbitration agreement does not exist if it is illegal. That is also okay. Document is not.
What we can perhaps understand,
Please.
Unstamped agreement, it exists.
Exists.
It is not void.
It is valid.
It is not even voidable.
So it is valid. Existence is there. So validity is also there.
Only thing is, with the meaning of section 35, you want to enforce it through a court of law.
I'll come to 35 later. Yes.
Evidentiary law. It remains in suspended limbo.
Yes. You can continue with the transaction.
You can continue with
you can
goes through. You can't get the aid of the court
to assist you in enforcing your substantive rights and obligations.
34 and then get it stamped.
Yes.
It remains eclipsed.
It's there, my lord. I mean my lord, there are colorful sentences that the Stamp Act does not impact the lifeblood of commerce. There are some sentences in that judgment your lordships had seen. Perhaps that can be.
Yeah.
So, my lord, the conclusion. My lord, ultimately My lord, on a very practical note, my lord, I'm giving up, though, my lord, there is some element of confidentiality. It's actually very simple, my lord. The agreement comes to you as the arbitrator.
So you are reading 147.
147, one comment. Existence and validity are intertwined, no problem. An arbitration agreement do not exist if it is illegal, no problem. Or does not satisfy mandatory legal requirements. Does this cover Stamp Act or not? It's not a mandatory legal requirement which makes it void. Supposing, my lord, invalid agreement is no agreement. Fair enough. If it's invalid, it's not an agreement. Your lordship can expand existence to include validity. That much, my lord. One can have that.
Supposing tomorrow the law is amended and it is said that to be a valid arbitration agreement, it should not only be stamped, but it should also be registered. It's just extending just to understand it. And you have to read it placing it side by side with section 49, the effect of not registration.
My lord, yes.
Tomorrow they say it should be registered, so that we need to have.
We need to know. My lord, then
what would happen then?
Then, my lord, then it would perhaps, my lord, void the agreement.
It would void.
It would void the agreement.
Void the agreement.
Then, my lord, I would then have to argue that existence is even narrower than validity. But for present purposes, my lord, that is not necessary. In fact, the English Stamp Act.
Well, why we said that it does not satisfy mandatory requirements.
Yes. So mandatory. Yes.
In a future situation where registration is made mandatory, then it would not satisfy mandatory legal requirements.
It would be, in fact,
the law would perhaps be
contrary to public
that requirement.
It would not be non-arbitrable. It would be contrary to public policy. It would be all sorts of things would arise. My lord, in fact, the judgment of Justice Lord Williams mentions certain provisions of the English Act which void it. My lord. If it is to be avoided, it is voided. Then, if that was our Stamp Act, then, my lord, all this would have.
What is the current English Stamp Act? Lord Williams is it?
My lord, current English Stamp Act, my lord, current
stamping
will require stamp. My learned friend has put it on records. It will require stamp.
Province of 6 countries, including UK, Singapore, Malaysia, who are the preferred destinations. Each of these Stamp Acts has the identical provision.
English Act is a little different. But, my lord, I will come to the Stamp Act and show, my lord, that in the vast majority of cases, actually, document does not require to be stamped, even though it has an arbitration clause. Even though a document has an arbitration clause, my lord, stamping is not required. I'll show that also. So, my lord, on a very practical note, if somebody comes to you and sitting as an arbitrator, and that document is placed before you, and it is said by the other side that it is unstamped, it takes, my lord, one hearing to decide it. You decide it, either one party pays, the other party pays. My lord, normally, I think this is a misconception. My lord, courts take the easy way out and impound it and send it to the collector. But 38 permits the court itself or the arbitrator himself to do that exercise. Straight away. 38.1 Stamp Act specifically permits the court or arbitrator to do the exercise themselves. So I can sit and, my lord, that is what we are now doing. You look at the agreement, you look at the Stamp Act, you impound the document and you collect the duty with the 10% penalty and send it off. Finished. One hearing, it is over. Either one party pays, the party who wants the arbitration to go on will pay and recover it through the arbitration process. So, my lord, there is really no delay when it goes before the arbitrator. The delay is because the courts do not have, my lord, the time. It's simply a matter of time, my lord, and my lord, opportunity to decide it. Mr. Banerjee will come and say it is stampable. I will say Article 43 applies. He will say, no, Article 5 applies. You file counter, you file rejoinder, you file written submissions. All right, I now impound it, I send it off. Or I ask the registrar to do it. That also your lordships have not permitted. There are judgments where only the court has to do it. Only the court has to do it.
That's why you see the Indian Stamp Act. 33 read with 35.
Right.
And 30 and 40.
38, 40, 42
It's a complete mechanism.
is a complete. And then 61, which is the revision.
That is different. But still, that will not hamper the proceedings.
Well, Lord, today that's the only issue. Whether
Should not hamper the proceedings.
That's the only
Once
issue.
the arbitrator decides and say this is the stamp which has to pay, and send it to the collector. Collector may examine and whatever the deficiency is there can be taken care
other
of.
side will challenge it. Well, Lord, normally,
Oh,
I can say this.
Insufficiency of the stamp is not a question to be examined. Let the collector do it.
In fact, my Lord, the practical reality is this is now the first defense one is suggesting.
Correct.
Section 11 is
Who is not interested for participating in
immediate
arbitration.
defense. Immediate defense.
The only they will put this question and leave the matter open.
And my Lord,
together.
the
And
answer,
then 34.
answer is also not arbitration agreement. My Lord, there's one other problem. If your Lordship is 33.2, the other 33.2 is very interesting. My Lord, we play it out. Supposing this document is placed before me, the under 33.2, I can't examine only the arbitration agreement. I will have to examine the entire instrument. I will have to extract the entire duty for the entire instrument, which will necessarily make me go into the substantive rights of the parties. Is this an agreement to sell? Is it an agreement of, my Lord, of development agreement? Then I will have to forget, my Lord, it's not a question of 8 annas anymore. It is not a question of 5 rupees anymore. It is then you go to the substance. So, my Lord, whether the 33.2 examination of the substance is something that was contemplated in 11.6. 11.6 examination is existence of arbitration agreement. But 33.2 requires you to examine the entire document.
Instrument itself.
Instrument. And you go beyond the arbitration agreement. 33.2.
That's one thing. The contract which is executed to the parties does not contain the clause of arbitration. But they say one clause. There are general rules applicable to the parties as we are transacting every time, running business going on.
Incorporation.
Like, that will apply. And that general rules have a clause of arbitration.
Correct.
Now, but the contract which
Doesn't have it.
It does not contain.
Right.
What will this situation do?
But then the instrument before you, if 33.2 is to be applied, then you will have to stamp the substantive agreement.
Oh, that's one thing. We're talking about 6A.
6A, my Lord, then you will say that the arbitration agreement exists by incorporation. Incorporation.
By incorporation.
And then refer it to arbitration. That's, my Lord, that MR engineering, there is a series of judgments there.
Then also theory of stamp will come.
Then also theory of stamp will come. But then stamp of the main agreement. But that's the problem. No? The problem is that in the process, existence becomes existence of arbitration agreement, existence of the entire agreement, existence of substantive rights, stamping of substantive rights, duly stamped how much money will you have to pay, then who will have to pay, how much is the penalty, then, my Lord, the hole in the dike of the dam. Your Lordship knows the
The portions which are doubted are paragraph 146 and
147.
7 consists of many.
Many. Lord, I'm showing the paragraphs which are problematic.
So which are those paragraphs?
147.1.
Yeah.
Then, my Lord, effectively, my Lord, 147.10. 10. Others, my Lord, it can, my Lord, Lordships may not, judicial, this, that, my Lord.
We need to be concerned with that.
There are some, my Lord.
So 147.1 and 147.10.
And 11.
11, my Lord, balances the forum and then knock out meritless litigation. My Lord, then your Lordships will have to go to 11.6 and, my Lord, then one will have to argue 11.6 at the
different
pristine level, and then, my Lord, we'll go through all of this. And, my Lord, I have actually done that exercise in the note. I have picked out every paragraph in the note.
Who is the 147.10? Why are you saying?
In addition to Garwari ropes, this court in Nabiram and Hyundai, both decisions of 3 judges, and Hyundai has rejected the application for reference in the insurance contracts holding that the claim was beyond and not covered by the arbitration agreement. Court felt that the legal position beyond doubt scope was fully covered by dictum and Vulcan. So, my lord,
This is just a, reference to what was actually done by the court. What is that view?
my lord, it in a sense, my lord, approves at 113 because, my lord, 147.10 is the conclusion to 113 to 115. The judge relies, my lord, on
If it is a factual narration,
if it's a factual narration, my lord,
capturing what had been done by the earlier case in the earlier cases.
Your Lordships,
The problem lies with those cases, not with the
no, that has been made a basis for Garwade.
Huh?
My lord, Hyundai is one of the reasons supporting Garwade.
True, but what Dolia has nothing to do with it. It's just saying it has been done like that.
My lord, 113.
So,
That your lordships can my lord, say that. But
which is we are just saying that perhaps the only paragraph is 146.
146, my lord, and my lord, 11.
yes, may I just submit one thing? In Ellen Global judgment,
Yeah.
what is the copy that I have is from the judgment of the court, not the SCC one.
Yeah.
It is 6.112. We doubt the correctness of the view taken in para 92 of the three-judge bench in Vidya Dolia. Now, para 92, if we read it, it is only para number 146 and 147.1.
That's it.
0.1 only.
That will not come in.
That will not.
Because 10 is
Just
a chronicling.
Not very, no, it's a chronology, but it's
Yes. Match it word by word. It starts at one.
That's right. We have to only
147.1 I have also shown your lordship. The question here is, and this is, my lord, essentially approving Garwade, and 146 is, my lord, to the extent that, my lord, there are some comments regarding existence.
So this is substantially what more you have to say? We just wanted to.
My lord, I only have to deal with the 40 Act. I'm not showing NN Global.
Which act?
1940 Stamp Act, my lord.
Go ahead.
And my lord, the question of admissibility and acting. This is it.
That's it.
Because, my lord, thereafter there is NN Global. I am not reading NN Global. All those arguments,
He
my lord,
referred to 92, paragraph 92.
my lord, NN Global paragraph, there are.
No, not
No.
Global. Dolia.
My lord, NN Global.
147.1.
Correct. 92.
Which is equal to 92 in the judgment. Because
No, I've got 146 and 147.
147.1.
No, one kahan. SCC seems to suggest something.
One, it starts here, 147.1.
She will give me one second.
Yeah.
Between the SCC copy and the reported judgment. There seems to be some slight. I have got the SCC copy, which only mentions 146 and 147. But what my learned friend says is that these are numbers which have been substituted by SCC, and actually the reference is only to 147.1. I'll check it up.
147.1 is what is really at.
Yes. That is clearly.
147.10 is not there.
In fact, my lord, I will go one step further and say, my lord, at least 10, 15 years ago, just by way of a side, 2 minutes a day, 10, 15 years ago, we were, maybe 20 years ago, we were prohibited from citing any journal other than SCR.
That's right.
And if your lordship insist on that, then this problem will, and now that your lordships have put it on the net ESCR, everything is there. It's the same scan. So, my lord, if the court now insists then we will all fall in line. Then this problem will not arise. Reported judgments.
At the time, this court was not accepting Xerox copies.
Yes.
Now everybody is asking Xerox copy because it's more convenient.
But Manoj, SCR, ESCR.
More convenient.
But certainly, Manoj, there is some sanctity to it. ILR and SCR.
We are
both
having issues
instances.
about the editorial notes.
Yes.
So
Judges used to settle it.
the Supreme Court is taking the initiative to have the editorial notes also prepared more or less simultaneously. So ESCR is going to be at the same space as the other journals.
It had almost caught up, my lord. It had almost caught up few years ago. But until the court actually pressurizes the bar to comply, we find SEC or something else much, my lord.
Today you are giving us a reason to enforce that.
My lord, this seems to be this.
This example.
This example is it.
This is also Manoj in Indian Global, the judgment, which what we got has very separate paragraph numbers.
The paragraph numbering is different.
Has a different
Paragraph.
Other problem is earlier it was not the practice for judges to number the paragraphs. It used to be a,
Now we are giving indexing also.
now we are giving index.
So, my lord,
It used to be flowing text.
So, my lord, all that remains is 1940 Act and the Stamp Act issue. That's all that remains. I just then I'll not conclude. I just read the last 2 pages after that. But please, first, I'm not going to take too much time on this. We've already gone back and forth on the Stamp Act. My lord, first, if your lordship sees what happened at the 1940 Act. This also I won't take too much time on. I'll just show this. And then, Manoj, what is my submission on the Stamp Act? This is a compilation on the stamping of arbitration agreement under the 1940 Act. This was a different regime. Manoj, what I have done is I have put the first edition of Justice Bachawat's book on arbitration. As your lordships would know, Justice R.S. Bachawat was probably one of the finest arbitration judges, apart from, my lord, whatever else he did. He was one of the finest arbitration judges, at least, my lords, we have seen. And post-retirement, he wrote this, and I put the first edition because this was all essentially authored by him. And it was authored in a very different style from what now the Bachawat arbitration is a very different creature, but he wrote it in a chapter form. So I have just culled out 2 pages of that with the judgments. I'll just, my lord, may just come to page 2 of this compilation. Stamp duty on arbitration act. An agreement to refer a dispute to arbitration is chargeable to stamp duty. Well, there are 7 or 8 judgments. All are footnoted. All the judgments are annexed in this compilation. That's how it has been made. Page 2. An agreement to refer a dispute to arbitration is chargeable to stamp duty under Article 5 of Schedule 1 of the Stamp Act. This is why I was having little difficulty arguing to the contrary. But, my lord, these are all, of course, my lord, High Court judgments which construe the Stamp Act. This is a judgment of Calcutta High Court. I'm not going to read it. My lord, please see the next proposition. And it will have immense relevance to the present case. An arbitration agreement contained in bought and sold notes relating to sale of goods is chargeable under Article 43 and not Section 5C. It should be Article 5C of the Stamp Act. And, my lord, this judgment starts at page 13. My lord, para 3, if your lordship sees.
So, Banerjee, if you just come back to page 4.
Page 4.
That's part of
Yes.
There is reference made to a judgment of this court. I don't know whether it will throw any light. It refers to a case where the impossibility of referring it back to the arbitrator You say, if arbitrator is Santo officio making, on the making of the award, it is no power to carry out such a direction. That is, to rewrite on stamp paper that was reported in 1962, supplementary 1 SCR corresponding to AR 62 Supreme Court, 551. We may, because the judgment of this court, we should have a look at it.
My lord, this is a.
Just take AR 62 Supreme
Yes,
Court.
no, I'll just cite that. But this is
551.
this is at the stage of award.
That's right.
This is at the stage of.
Because this court has spoken, we should have a.
Yes. My lord, we'll just get them. In the meanwhile, I'll just run through these other 6-7 judgments.
Yes.
So that, my lord, if your lordship sees footnote 17, it refers to Bombay Company, which is at page 2. Arbitration agreement contained in bought on sale notes relating to sale goods is chargeable under 43 and not so and so of the Stamp Act. Now, my lord, please come to that judgment. It starts at page 13 and it comes to page 14. 14, somewhere, my lord, paragraph 3. First, with regard to the question of stamp, and I'll explain what is the significance of this in our case. The same objection is taken in so and so. Learned judge stated no way out, difficulty, but it is the only objection thought that the court could remedy. Now, the contract in this case, as in that, is comprised in bought and sold notes, each signed by the brokers and stamped under Article 43 of Schedule 1 to the Stamp Act with a stamp of 2 annas. This contract contains a number of printed clauses or conditions, the last of which, clause 12, constitutes the submission to arbitration. This is a live example. The petitioner's counsel made some attempt to argue real contract refers contained in subsequent letters due to applying the ruling of Bombay High Court in the case of Gangaram Kushobai Rangole. I have annexed it, but this was clearly not the case. In my opinion, however, the agreement to refer any dispute whatsoever arising out of the contract to arbitration is part of the contract itself and not a distinct matter within the meaning of Section 5 of the Stamp Act. If this be so, the whole contract clearly falls under the exemption. Clause A to Article 5 being an agreement or memorandum of agreement for relating to the sale of goods or merchandise. Only exception to that exemption, contract is also Y note, chargeable under 43. Contract contained in such notes are duly stamped. This view of the matter does not appear to have been before the mind of the learned judge. So, my lord, here, what does the judge do? The judge takes the document, the entirety of the instrument, he reads the arbitration, he reads the Stamp Act, he goes to Article 43, he goes to Article 5, he goes to the exemption. My lord, will this be permissible in 11.6 today? That's the question, my lord. In 33.2 is the 33.2, my lord, this is the exercise he will have to carry out.
Yeah.
This is the exercise which was carried out under the old law, my lord. But will it be permissible today? Will you want this court today or any court today to look at the instrument as a whole? My lord, there is a...
Possibly was in the 1899.
Right, 89. My lord, the proposition is this. The object is to restrict to examination of the arbitration agreement. My lord, I go one step further. Your lordship may say it is to restrict to the examination of the stamping of the agreement. My lord, I may have a problem with that. But in doing that, you will necessarily, because, my lord, I have conceded that it is one instrument. My lord, we are not going on the theory of two contracts, but there's a flip side to it. The flip side is that if it is one instrument under the Stamp Act, then the appointing authority will have to look at that document. That's the normal case, my lord, which comes. It's always the contract with the arbitration clause at the end. Then he will have to look at the document. My lord, then does he confine himself to the arbitration agreement? Forget the word existence. He is not confining himself to the arbitration under 33.2. He cannot confine himself. He has to look at the full document. He has to give the duty on the full document. He has to go into the Stamp Act. So, my lord, I submit that because of 11.6a today, 33.2 cannot be operated as it was here. So, my lord, this example shows what the problem was. And, my lord, how this was. And, my lord, in fact, one other very interesting thing. All the judgments are post-award stage. There is no judgment I could find which was at the initial stage. Even then, my lord, and all the judgments, though this book was written in 1983, just a few years after his retirement, many years after his retirement, just 2-3 years after his death, all the cases your lordship will see 1912, 1918s, because my lord, then there was an issue of separate arbitration agreements. Today, 99.9% of the cases, the agreement is the one which has all the substance and all the clauses. My lord, it is very rare to write a one-page letter saying, I refer my disputes to arbitration. So, my lord, today, if we are to do this and thrust it upon the 11th judge, he will have to do this also. So, my lord, this is where the problem is. And my lord, therefore, I submit that because of this circumscribed, my lord, jurisdiction, this is not a burden which we are to give. My lord, I'll show one more case. Please come to page 3. Please come to page 3, third paragraph. Another example, practical example. An agreement for sale of goods which is exempt from stamp duty does not require stamp, though it contains provisions of warehousing, insurance, and reference to arbitration. Because sale of goods, the substantive my lord, agreement is exempt. My lord, Mr. Datar was mentioning examples where the substantive agreement is exempt in backward areas. Are we going to request the appointing authority to go into this? Or are we going to leave it to the arbitrator to solve the problem? So, my lord, these are concrete examples of cases where previously the courts used to go into it. Now the legislative intention is not to go into it. So, my lord, these are 7 cases. I've just put the cases there. Now, my lord, the last issue, but by no means the least issue. What is the correct way of reading 33 and 35? 2 answers. Because that's the elephant in the room, my lord. 2 answers. My lord, one I had argued yesterday, I'll give a note. My lord, the submission is, you give the note. No, this I have already argued, I'm just putting this one in. My lord, there is another way of looking at it. There are 2 phrases used, assuming 33 and 35 applies. My lord, my first case is that 33 and 35 don't apply. They don't apply at the stage of appointment, but they do apply at the stage of
16.
No, not even before 16. It's the first thing they raise. No, you don't wait for 16. Good morning, I object. No, that's at least that is what happened in my case. This is not stamped. So you sort it out at the beginning. You don't even wait for a 16 of pleadings. So, my lord, that is one way of looking at it. My lord, assuming I am wrong, this is not an argument your lordship wish to accept. It is an alternative argument. My lord, the alternative argument is that section 33 and 35 give rise to an evidentiary bar. Now, the answer which will be coming from the bench is, it is not only an evidentiary bar, but it is not only admission to evidence, but acted upon. I'll take these 2 separately. My lord, admission to evidence under the CPC, as your lordships know, my lord, comes at a little later stage. Pleadings are completed. It only comes at the settlement of issues. Order 13 only comes at the 12-13 comes when issues are settled. And impounding finds place in order 13 of the CPC. At that stage. So, my lord, if we take a parallel, though it's not really fair to take a parallel, you have a section 21 notice, you start the arbitration, and you complete pleadings, then you come to evidence stage, then, my lord, at the evidence stage, you have admission denial, admitting documents, the arbitrator, my lord, may step in there. So he may step in earlier because of section 17 relief or whatever it is. But assuming, my lord, that all this is not correct, and I have to meet both conditions of admission and acting upon, my lord, there is one article I want to show, which explains, my lord, this very nicely, and I'll just show that article. It's already on there. Compilation part formula.
Compilation?
4. My lord, there has been a lot of writing on this way, that way, the other, but some of the articles are very interesting. One gets very interesting ideas. That's why I put out 6-7 of them, just to see, my lord, what their ideas are.
Balaji, guide us on this issue also. Suppose we agree with you that in the guise of this existence of an agreement, you can't make the scope so vital
Right.
and start examining the stamp also, whether it's stamped, unstamped, insufficiently stamped.
Correct.
These are not the issue of.
Correct.
All right, we proceed. Now we appoint the arbitrator.
Right.
Now our job is over. The court's job is over.
Right.
Now we go to the arbitrator.
Correct.
The man who is not interested to participate in arbitration, the first recourse would be
Raise the point. No problem.
No, what we want to know from you. He can't brush aside by saying that you go and raise an objection there and let the matter be dumped over there. No. We want the smooth functioning so that the arbitration must be concluded within the time bound with whatever the objections the parties interested available under the law.
Correct.
Within the time framework.
Correct.
So to have the time framework to continue and the parties, regardless of their objections, which is validly to be raised, available, can also be meted out.
Correct.
Otherwise, what will happen? If we accept your view, at least we have shifted our burden.
Correct.
Now send to the arbitrator.
Right.
Now, in the arbitrator, the people raise an objection and start.
Your Lord, your
Want
Lord.
that mechanism to
Yes.
go ahead.
I will
So
suggest
that it may conclude within the time bound in terms of the legislative wisdom.
some guidelines your Lordships can.
Otherwise, what will happen is we are just putting a. Now we are running into pages and pages and pages. Ultimately, we are not doing justice to the man who is before the court.
Right, Manoj.
Ultimately, we want that it must go to a level where the person are expecting from granting relief by the courts.
Correct. That's the
And the ground reality has to be kept in mind.
Your Lordships, Manoj, I can suggest some Manoj, guidelines
So
as
that
Manoj, practically
should not stuck there.
it should not be stuck there. In fact, Manoj, there are three possibilities. One is once the party realizes that this is not really a good defense in an 11th stage, he may just not even raise it. That's one possibility. Even then, Manoj, the arbitrators is required under law to look at it. Alternatively, one party will raise it, the other party will pay to buy peace and get on with it. My lord, that is what is usually happening, and then go through the procedure and recover it. So there are, my lord, 3-4 possible. I'll formulate, my lord. Your lordship accepts it. I'll formulate some possible guidelines.
Better for guidance.
Because my lord, one advantage of arbitrator.
Working before the arbitrators also.
One advantage of arbitrator is he or she can decide it themselves. That power is there with the court also.
33, you can do it and send to collector thereafter.
My lord, may just see 38 one end.
38,
1 versus
38
38 2.
that's correct.
You can actually collect the duty, collect the
And send to
dependent,
collector.
send it to the collector, get a certificate, and send that person off to challenge or do whatever he wants to.
What
That
happens
proceed.
if the arbitrator doesn't have any, is it necessary that he has judicial experience, a technical person
Technical person, my lord,
can also be an arbitrator,
can also be an
sole arbitrator?
sole arbitrator.
So he may not have any, judicial kind of training or understanding of.
That happens, my lord. We have to face that issue, my lord.
No, when it comes to stamp duty, we're talking about.
He is empowered, my lord, by consent of party.
Therefore, would we know that?
My lord, then there will be many more problems
Because
other than
he's
stamp
chief
duty.
engineer.
My lord. That will be the least of the
Apparently,
problems.
he's a chief engineer.
Sorry, my lord?
He's a chief engineer. Technical man.
An engineer.
An engineer.
Engineer.
And he's an arbitrator. He doesn't know so much of intricacies and ICTs of this problem.
Right.
Now, if he raise an objection there,
We'll send it off.
now he put his hands up by what to do.
Impound and send off.
That's correct. So he must have some background to know about it. And what is my role to play such an objection nothing raised?
One of the problems that may arise is it is an order of a court which sends a document to a collector and says, you please assess within 45 days in view of Garawai, give it back to the court. Suppose this is done by the arbitrator, an individual. I can be an arbitrator. I can be an arbitrator. I can be appointed an arbitrator. I write a letter to the collector. Please evaluate, send it back within 45 days in view of Garawai. Collector, I'm an individual. I don't have any statutory backing in the sense
There
that
is.
it's an interim order under 17.2, which is deemed to be a decree. One. the award is deemed to be a decree. So by legal fiction, his orders are enforceable.
You want to say, you ask you 45 days, even 145 days, the document is not returned.
My lord, even
In
with
this case,
45.
No. I'll tell you. In NN Global, the letter came from the registry. I submitted. It was sent and adjudicated. Amount paid. That's it was done. And the lordships have put a very pointed question. Ordinary person can be appointed as arbitrator. How will he look at the stamp act? And what will he? Because 27 requires.
Certain things are to be presupposed. If you are an arbitrator, you are presupposed to know. You either don't accept. You are presupposed something.
Suppose in a family setting, two branches of the family, say the eldest member of the family is the arbitrator, whatever he decides, final. Then,
They are
what
conciliators.
is the sanctity of an
They are
order?
not
How to
arbitrators, they are
enforce?
conciliators. They are conciliators.
Lord, we'll suggest some guidelines to
The problem
deal with this.
becomes enforceability. Because the court sending a document has the power of the
Is there
authority
any
of the court.
mind? Suggest something so that
We'll suggest. My lord, may just see 3 pages of this, and I'll, my lord, conclude my submissions, and I'll just, my lord, make my points. This is an article 102 by an advocate in the Bombay High Court. My lord, I had some discussion with him, and he sent me this article, my lord.
where do we find it?
The volume 4, my lord, page 102. My lord, this is one view, but I believe, my lord, the discussion on section 35 between pages 102 and 104 would be, my lord, relevant. He explains, my lord, the breakup of section 35 and what you mean by acted upon, what you mean by persons authorized to receive. And, my lord, it's a very interesting analysis. He relies on the Allahabad High Court Bitten BB. I've put a copy of that in, and that has been approved by my lords in Hindustan. So, my lord, this analysis at one
judgment on acted upon.
This is, my lord, he analyzes acted upon, and, my lord, that
You're looking at a
Any judgment. Any judgment.
my lord, Bitten BB, which is the full bench judgment of the Allahabad High Court, my lord, explains when these, my lord, there is no judgment specifically I could find, my learned friend, on
No judgment.
No. These 3 terms to
acted upon, my lord, then I think it is registered, something else, my lord. There are three words, my lord.
For the statement of objects.
My lord, we have the of the Stamp Act, my lord, there is only act to consolidate fiscal, my lord, that is discussed in it. But, my lord, this interplay of 33 and 35 has been dealt with by the Allahabad High Court in a full bench. We have put it in, and that full bench had Justice Raghubar Dayal, Justice Desai, and one other. Justice Desai was in the minority. The Supreme Court overrules the minority, which was really not required. By that time, Justice Raghubar Dayal had come to the Supreme Court, but was, of course, not on the bench. So the majority judgment in Bitten BB has been approved in Hindustan, my lord, Steel, which I had showed myself. These 2 pages are this gentleman's analysis of, my lord, Bitten BB and Hindustan Steel, where he says that the bar is an evidentiary bar, and the acting upon, so far as judicial, my lord, the section contemplates 2 categories of people, 35 and 33. One category of people are like arbitrators, judges, who are authorized to take evidence.
We'll give you an example.
Authorized by.
This structure. See, supposing an unstamped document is allowed to come into evidence. So it can be.
Then no problem, my lord. 36.
No. We are just trying to
Yes.
give some meaning to the words acted upon.
Yes, my lord.
So, assuming an unstamped document comes into evidence,
Correct.
can we possibly say to more meaning into the words shall not be acted upon. That when the court finally adjudicates, writes a judgment,
Right.
decides a list,
Correct.
it will not enforce that unstamped.
No, this was the exact point in Bitton BB which has been approved. This was the exact argument which Justice Desai accepted. He said that there is a dual qualification. The majority said no. So far as judicial officers is concerned, the bar is evidentiary. Acted upon is the second stage. If you clear the evidentiary bar, it would be, and 35 was not interpreted in isolation, it was interpreted along with 36. Because 36 does not have this acted upon. So, Your Lordship will just read these 2 pages. It's there.
Yes.
So, my Lord, in conclusion, my Lord, my submissions are in the last page, I'll just show. And, my Lord, I've taken a lot of Your Lordship's time. My Lord. Please see the last.
But you are the amicus. So
My
we
Lord,
should be grateful to you.
my Lord,
The court should acknowledge the work that you have
my Lord, I must say, in all fairness, my Lord, it is certainly not my individual effort, my Lord. I am merely the face. There are 3 gentlemen standing here who have contributed. Various other people, my Lord, have.
Team, because you have put
Yes.
up so much work.
And all sorts of persons from all sorts of all walks of life have, my Lord, put in their ideas. 6:30 in the morning, Mr. Datar called me with something. So everybody, my Lord, is putting in there, because, my Lord, ultimately it's a matter of approach. Your Lordship, my Lord, the question, there are two my Lord, end results are possible. But I am advocating for one end result, my Lord, simply because this interpretation that you do this at the outset, my Lord, will defeat every thought of arbitration, my Lord, right through. So if this is the necessarily only conclusion, Your Lordship will go for it. But, my Lord, I think there is enough material to show that, and, my Lord, we have set it out, and nobody is going to get hurt. My Lord, the government of India or the government will not get hurt. They will get their money, my Lord. They will extract their pound of flesh just a little later. That's all, my Lord. It's a win-win. It's a perfect balance. The arbitration will go on. Government will get its money. My Lord, both statutes will work. The alternate is neither will the government get its money, nor will the arbitration go on. So, my Lord, those are my respectful submissions. I'm deeply obliged.
Yeah.
Not Lydia. Lydia.
Convenience compilations.
You got 6, 7.
Three. Just briefly introduced. My compilation 1 is the relevant provision of the stamp act, criminal stamp act, another system, SMS, and 3 judge-based judgments.
The problem is people never consult each other before the compilations are made available to the court. And there's so much of duplicacy. Because you can't get some material from other way around. Duplication is such.
Otherwise, you will say.
I correct, yeah, duplication. So much of duplication is there. Because we go to one convenience volume, then becomes second convenience volume, the same.
Convenience volume, common convenience volume.
Creating inconvenience.
What my learned brother was trying to hint at is indirectly,
That should use
in a graceful manner, that some time limit is what he is trying to say.
Better it is.
Isn't it?
Better it is. Because you understood one line of action is there.
No, but then of course you should have a full explanation. Should hear you. Just we are not forcing anything, but that. Yes.
Let's, the first compilation has judgments of SMS, Jnana Patra, because that is referred. Blackburn, a 3 judge-based judgment, which follows SMS, which has been overruled. Then another 3-page judgment in Dharma Ratnakar. Both of these judgments are not noted in the NM Global judgment. Both of them follow SMST.
There were 3 judges?
Yes, Manoj. That's why all the compilation is.
Oh.
My second compilation was, convenience compilation 2, is restrictive to few provisions of the Arbitration Act that we have seen. and then judgments on legal fiction. Because the section 16 in my submission, as noted by Vidya earlier, is a case of a legal fiction. It is created for a very specific purpose. First, the purpose is set out, and then the fiction is created. The settled law is it is to be restricted for the purpose for which it is created to this section. It cannot operate to any other section, much less to a different act altogether. That's my second. And I begin by Bengal immunity, 11 judges, 2 constitution-based judges. And then it also has 2 judgments dealing with statutory fictions created under section 17(2) of the Arbitration Act. That is in Amazon. And then Vedanta, again a statutory fiction under section 36. The judge notes that these are legal fictions, limited, and then follows Bengal immunity, 11 judges, not to go beyond the fiction. It is my understanding, of the judgment in NN Global, para 6 and onwards, that this concept of a legal fiction has been stretched to mean that the arbitration agreement is a document at all which is separate. It has a separate existence. So maybe the main agreement is not stamped. Still, it will not affect the validity. The separability will come to the rescue of the arbitration agreement. That is one. That is my understanding of NN Global, which in my submission is not correct. Then, my third convenience compilation, it is the entire Indian Stamp Act. It has 3 judgments of this court, 2 judgments of this court, and 1 of the Privy Council as to how Indian Stamp Act was interpreted, 2 provisions. Then I have also put in 1 judgment of the UK Supreme Court as to now how the concept of separability is being restricted for the purpose for which it was created. It is not a magic wand which, if you use, would make all legal bars disappear. More so when it is created by a separate act. Then, I have pointed out in this volume, there are 6 stamp acts of different countries. Each have identical provisions imposing bar. Bar document must be impounded, would not be acted upon. Those are my basic volumes. Now, can I invite my Lord's attention to some provisions of the Stamp Act? My learned senior.
You are supporting Vidya earlier.
I am not supporting it. Yes. I am saying, my contention is very simple. SMST is the correct law. It is not required to be overruled. Garwale is the correct law. Just because Garwale was cited with approval in Vidya earlier, that did not make any difference according to me. And in NN Global, what was done was SMST overruled Garwale because it is affirmed by a 3-judge bench, doubted, and then the reference comes to your lordships. If that be the reasoning of the reference minutes, what the learned court forgot was SMST by itself was followed by 2 3-judge bench judgments. Garwale was followed by Vidya 3-judge bench. Therefore, the parity of reasoning that I will...
The other 3 judgments were 3 bench was not noticed.
No. And in fact, Zolia came in when this NN Global was closed for order.
Straight away shows those 3 judges bench.
Certainly.
Let us straight away go to that. Which are those?
Your Lordships may have convenience compilation 1.
With the citation, if you don't.
It is 2011, 14 SCC.
2011, 14 SCC.
Page 66.
Was that brought to our notice? Government manager, did he bring it to our notice?
My lord, I brought it to your lordship's notice. The judgments do not consider 11.6a. These judgments are pre-11.6a.
That's right.
SMSP is 11 pre-11.
No, SMS, but
even these judgments, my lord, do not consider, only Garwadi considers 11.6a.
Oh.
These judgments do not comment on 11.6a. They simply follow SMST. And my lord, I had also mentioned, your lordships will recollect, that these judgments arise from matters where pre-11.6a reference was made. Therefore, my lord, I had mentioned it, but I should have mentioned it more, my lord, forcefully.
It is Garwale basically, which is 11.6a and the interplay as to whether 11.6a overrules the SMS principle. It says no. Now, may I just first show SMST judgment which was overruled. The Lordships may straight away come to para 70 of the SMST and para 90. It notices that Registration Act Section 49 has a proviso which saves the document from being used for a collateral purpose. There is no such proviso in Section 35 of the Stamp Act. Now, para 17, the second question, which is stamping, starts. What if an arbitration agreement is contained in an unregistered but compulsorily registrable instrument which is not duly stamped? Then it notices Indian Stamp Act Section 33 and 35. Then 19 is the discussion. Having regard to Section 35 of the Stamp Act, unless the stamp duty and penalty due in respect of the instrument is paid, the court cannot act upon the instrument, which means that it cannot act upon the arbitration agreement also, which is a part of the agreement. Section 35 of the Stamp Act is distinct and different from Section 49 of the Registration Act in regard to an unregistered document. Section 35 of the Stamp Act does not contain a proviso like Section 49 of the Registration Act, permitting the instrument to be used to establish a collateral transaction. Then, these have para 20. The scheme for the appointment of arbitrators by the Chief Justice of the Guwahati High Court, 1996, requires an application under Section 11 to be accompanied by the original arbitration agreement or a duly certified copy thereof. In fact, such a requirement is found in the scheme and rules of almost all the high courts. What if is produced is a certified copy of the agreement, contract, instrument containing the arbitration clause? It should disclose the stamp duty that has been paid on the original. Section 33 casts a duty upon every court, that is, a person having by law authority to receive evidence, as also every arbitrator who is a person having by consent of parties authority to receive evidence, before whom an unregistered instrument chargeable with duty is produced, to examine the instrument in order to ascertain whether it is duly stamped. If the court comes to the conclusion that the instrument is not duly stamped, it has to impound the document and deal with it as per Section 38 of the Stamp Act. Therefore, when a lease deed or any other instrument is relied upon as containing the arbitration agreement, the court should consider at the outset whether an objection in that behalf is raised or not, whether the instrument is properly stamped. If it comes to the conclusion that it is not properly stamped, it should be impounded and dealt with in the manner specified in Section 38 of the Stamp Act. The court cannot act upon such a document or the arbitration clause contained therein. But if the deficit duty and penalty is paid in the manner set out in Section 35 or 40 of the Stamp Act, the document can be acted upon or admitted in evidence. Notice the submission is in para 22 and I am relying on 22.2. If the document is found not to be duly stamped, Section 35 of the Stamp Act bars the said document being acted upon. Consequently, even the arbitration clause cannot be acted upon. The court should then proceed to impound the document under Section 33 of the Stamp Act and follow the procedure under Section 35 and 38 of the Stamp Act. Then 22.4. Once the document is found to be duly stamped, the court should proceed to consider whether the document is compulsorily registrable. If the document is found not to be compulsorily registrable, the court can act upon the arbitration without any impediment. Now, Manoj, this is not without noticing the principle of Section 16 of the Arbitration Act. Please have para number 12 of the same judgment, SMST. So it is not as if the principle of separability was not noted. Para 12 of SMST. When a contract contains an arbitration agreement, it is a collateral term relating to the resolution of dispute, unrelated to the performance of the contract. It is as if it has two contracts, one with regard to substantive terms of the main contract and the other relating to the resolution of disputes have been rolled into one for the purpose of convenience. An arbitration clause, therefore, is an agreement independent of the other terms of the contract or the instrument. Noted. Resultantly, even if the contract or its performance is terminated or comes to an end on account of repudiation, frustration, or breach of the contract, the arbitration agreement would survive for the purpose of resolution of disputes arising under or in connection with the contract. Then, para 14 quotes section 16. Now just have a discussion at para 16. An arbitration agreement does not require registration under the registration act. Even if it is found as one of the clauses in a contract or instrument, it is an independent agreement to refer the parties to arbitration, which is independent of the main contract or instrument. Therefore, having regard to the proviso to section 49 of the Registration Act, read with section 16(1)(a), an arbitration agreement in an unregistered but compulsory registrable document can be acted upon and enforced for the purpose of dispute resolution by arbitration. So the court is very conscious. You have a proviso in section 49 which permits it. You don't have a proviso in section 35, can't be done. It acts as a bar. And when can be it acted upon? On payment of duty. There's a procedure to it. Now, Millers, please have the next judgment in the compilation, which is Naina Thakkar, which is the only judgment on section 8, where the section 8 application was dismissed by the court. This is, I am reading page number 43, convenience compilation 1. The learned counsel for the petitioner places reliance on a decision of this court in SMST and submits that the second additional chief judge in his order dated so and so in the application made by the petitioner under section 8, having held that the lease deed is insufficiently stamped, ought to have impounded the said lease and followed the procedure prescribed in the section 35 and 39 of the Stamp Act. And if the document was found not to be duly stamped, should have given an opportunity to the petitioner to make up the deficient stamp duty and pay a penalty if directed by the collector. Having not followed the above procedure, the said court committed serious illegality in rejecting the petitioner's application under section 6. Now, Millers, please come straight to, and this notes SMST in para 5. Please have para 6, 7. In the light of the above legal provision, when we look at the facts of the present case, we find that while pressing the application under section 8 of the Act, the petitioner did not show any inclination to pay the deficit stamp duty on the lease deed, nor expressed his desire that he was willing to pay the penalty as may be imposed by the collector, if the document was impounded and stamp duty payable thereon was determined. It is true that the consequences provided in the Stamp Act must follow when sufficient stamp duty has not been paid on an instrument, irrespective of the willingness of a party to the instrument to pay definite stamp duty. But the procedure, now, this is a bit for your Lordship's consideration. The procedure when the arbitration clause is contained in a document which is not registered, although compulsorily registrable and which is not duly stamped, as summed up by this court in SMST, shall not be applicable to the proceedings under section 8 of the Act, where the party making such application does not express his or her readiness and willingness to pay the deficit stamp duty and penalty. It is not the duty of the court to adjourn the suit indefinitely until the defect with reference to the stamp duty concerning the arbitration agreement is cured. Accordingly, the matter was dismissed. Therefore, the moment you file a section 8, you file a section 11, it is upon you to make the stamp duty deficit complete. Now, the 3-judge bench judgment notes, which is not noted, is at page 46, black hole, which follows SMST. Now, this is under the Karnataka Stamp Act, but provisions are identical. SMST is noted in para. In fact, you can have the discussion from para 8. This is a section 11 application being dealt with. At the outset, we think it appropriate to make it clear that we are not determining whether the agreement in question is a lease or license or an agreement simpliciter, as put forth by the learned counsel for the appellant. That is required to be dwelt upon and addressed by the High Court while deciding an application under section 11 of the Act. It is well settled in law that while dwelling upon the appointment of an arbitrator under section 11, regard being had to the nature of agreement referred to in section 7, the judge designated by the learned Chief Justice is obliged to consider the nature of the agreement and whether the document requires to be stamped or not, and if so, whether the stamp duty has been duly paid on the same. We are so stating in the instance case that there is a written instrument and there is a dispute as regards nature and character of the document. Therefore, Manoj, in my respectful submission, only 3 things: nature of the agreement, whether it requires to be stamped or not, and whether requisite stamp duty has been paid or not.
Prior to 6A.
This is prior to 6A. Now, Manoj, SMST is denoted thereafter, and then ultimately the matter is dismissed. The matter is then sent back to the High Court. That please, the High Court judge should determine what is the nature of the document. It notices SMST. in para 9. That's all I want to point out. In 9 and 10. 10 minutes comes Garwade. Garwade, your lordships have seen in its minutes. My only submission would be para 19 in Garwade is the correct Milord's interpretation of law. Para 19 of Garwade takes in account, or para, in fact, this is the section 6A, 11.6A. If the lordships would just permit me, I will show it from the beginning. Please have page number 62 in the compilation, para number 3. What is the question formulated in Garwade? Here. The question is whether 11.6A, which has been introduced by way of the Arbitration and Conciliation Amendment Act 2015, has removed the basis of this judgment. This is SMST, so that the stage at which the instrument is to be impounded is not by the judge hearing the Section 11 application, but by an arbitrator who is appointed under Section 11, as has been held by the Indian Government. So this was the exact controversy on which you do agree. Section para number 4 notes the arguments that it can't be looked into relying on SMS. Then the provisions of the Arbitration Act, the Maharashtra Stamp Act, because this was a case under the Maharashtra Stamp Act, were required unnoticed. Just have para 14, Law Commission report. The reading of the Law Commission report together with the statement of objects and reasons shows that the Law Commission felt that the judgments in SBP and Bogara required a relook, as a result of which, so far as Section 11 is concerned, the Supreme Court, or as the case may be, the High Court, while considering any application under Section 11(4) to 6, is to confine itself to the examination of the existence of an arbitration agreement and leave all other preliminary issues to be decided by the arbitrator. The question is whether the decision in SMST has also been done away with the expression notwithstanding any judgment, decree, or order of the court contained in Section 11. Again, precise question. Then SMST is noted extensively. SBP is noted, then 19. It will be seen that neither in the statement of objects and reasons nor in the Law Commission report is there any mention of SMST. This is for the very good reason that the Supreme Court or the High Court, while deciding a Section 11 application, does not in any manner decide any preliminary question that arises between the parties. The Supreme Court or the High Court is only giving effect to the provisions of a mandatory enactment, which, no doubt, is to protect revenue. SMST has taken into account the mandatory provisions contained in the Stamp Act and held them applicable to judicial authorities, which would include the Supreme Court and the High Court acting under Section 11. A close look at Section 11.6A would show that when the Supreme Court or the High Court considers an application under Section 11(4) to 6 and comes across an arbitration clause in an agreement of conveyance which is unstamped, it is enjoined by the provisions of the Stamp Act to first impound the agreement of conveyance and see that the stamp duty or penalty, if any, is paid before the agreement as a whole can be acted upon. It is important to remember that Stamp Act applies to the agreement of conveyance as a whole. Therefore, it is not possible to bifurcate the arbitration clause contained in such agreement of conveyance so as to give it an independent existence, as has been contended by the respondent. The independent existence that could be given for very certain limited purpose on harmonious construction of the Registration Act and the 1996 Act has been referred to by Justice Ravindran and SMST when it comes to an unregistered agreement of conveyance. However, the Stamp Act contains no such provision as contained in Section 49 of the Registration Act has been held by the said judgment to apply to agreement of conveyance as a whole, which would include the arbitration clause contained therein. It is clear, therefore, that introduction of Section 11.6A does not in any manner deal with or get over the basis of the judgment in SMST, which continues to apply even after the amendment of Section 11.6A. This is what is now para 20. It is now looked from a slightly different angle, and it is in this context that the provisions of the Contract Act, Section 2, EFGH are noted, and the conclusion or the finding is at para 22. When an agreement clause is contained in a contract, it is significant that the agreement only becomes a contract if it is enforceable by law. We have seen how, under the Stamp Act, an agreement does not become a contract, namely that it is not enforceable in law unless it is duly stamped.
So there is where Ms. Banerjee points out, the subtle nuance that to be not enforceable, it must be void.
Section 33.
You see the Contract Act.
Yes.
Enforceability is actually understood in the context of it being void. Or rather, unenforceability.
Yes, that is why
goes
my
to it
respect
being void.
it is qualified unless it is duly stamped. And judgment. Unless it is duly stamped. Your Lordship put it, it is sort of eclipsed. It is there. It is there. But till the time stamp duty is not paid, it is eclipsed. The moment you pay the stamp duty, the bar of the eclipse goes, it can be acted upon. It is admissible as evidence.
So it is not ab initio void.
No.
The agreement is valid.
Everything is valid. The transaction is good, but it is not enforceable till the time stamp duty is not paid. The moment the section itself says so, until the time stamp duty is paid. Just have a wording, just have a look at the.
So in a different sense, when you talk about enforceability, suppose you enter into an agreement, it is not stamped. Money is paid, services are rendered, parties fulfill their obligations up to a particular point, let us take, till actually they join issue, or at some point. What was the nature of the contract during the time it is actually utilized by both parties? Would you say it is not enforceable?
It is enforceable because the parties have acted upon it.
Acted upon.
On their own volition, they have acted upon it.
Therefore, can you say that it is not enforceable in that sense?
According to me, if you see the definition of in 2G of the contract.
As contrasted with the document which is actually void. Even there, of course, you can possibly say even transactions could take place between the parties purporting to act under the aegis of a void contract. Voidable itself is a very, very large.
It's very large.
Where
nothing prevents the party to enter into an oral contract. It's very simple. Oral contract, no stamp duty is required. Out of the Stamp Act. The problem comes when you start enforcing it. One party backs out. There is a problem in the contract.
The agreement requires an agreement in writing.
In writing.
So that difference is there.
That difference is. So let us examine this. The party comes to section, to make an application under section 8, 11 to do what? 9 to do what? And force the agreement. At 8, it says, sir, there is an arbitration agreement, no civil suit, it have to be sent to the arbitration. It is enforcing a term of the agreement, the instrument. Section 11, appointment of an arbitrator. The court, please look at the document, instrument, there's an arbitration clause, please appoint an arbitrator. That's acting upon.
Enforcing.
It's enforcing.
That's you.
You may do it on your own.
One thing you have to examine. Pre and post regime, 6A, one thing. A provision for arbitration is only opening a window for availing the remedial mechanism. It is nothing else.
Nothing else.
From the contract. You are not tinkering with the contract. What are the transactions, the business contracts you entered into? This only provides you a mechanism other than what is being prescribed by law, that you have this additional mechanism also, if the parties undertake, can avail this remedial mechanism. So the question to you would be that enforceability in reference to what? Enforceability in reference to the contract is one thing. Enforceability with the nature of a mechanism to adopt the parties in coming for arbitration is one thing. So the question is, that's why you are asking me, in 6A, it's only implementation. To what extent this, you see, implementation is section 16 also. Implementation you find in 16 also. Implementation you find in 6A also, 11-6A also. Now you have to examine as to what is the effect of implementation in 6A of section 11 and what is the implementation in section 16. 16 comes after the arbitrator take a call. 6A is up to the stage when the prima facie is to be examined. We are not going to go into the intricacies of it. So the question is, what is the effect of implementation in 6A and the same implementation of 16?
In fact, also section 8, because that's the first.
Section 8 also, correct? Section
8, 9, 11, 16. We all have to be.
Enforceability of commercial contract in reference to a transaction is one thing.
Right.
Enforceability of a remedial mechanism. What is enforceability? It's not to avail a remedy which we have agreed upon on an unstamped document.
Law is
Right, without 11 and 8.
Yes, yes, yes.
Let's, I put it.
Can come into existence. Supposing parties.
It's by consent. Don't go. No section 11 is there.
Whatever, no 8, nothing is required.
Go to an arbitrator. It is appointed. But then the arbitrator will be by law.
Problem is only when you travel through 6A.
Exactly.
In fact,
6A or 8.
8.
Or 8.
Water will come, go, let the train go. Don't worry.
कुछ नहीं बोलना हाँ योर सॉरी